Greetings, everyone. Happy Friday, and thank you for joining us again on Turning a Moment into a Movement. I am your host, Jay Love, and I represent the Justice for Gerard Movement. Gerard is my son who was wrongfully convicted of a crime that he didn't do, innocent, and he went to prison for that crime. He served 2 years in the Michigan Department of Corrections. He suffered from severe Crohn's disease while he was there. They lost his medical records, and it just was a lot of things that went on with that. But because of the journey with him and all the people I met on that journey, we created this platform called Turning a Moment into a Movement, where we come here every Friday along with attorney Hugo Mack, Reverend Tia Littlejohn, Trisha Duckworth, and Dwayne Brooks to talk about wrongful convictions, to talk about injustice, to offer a safe space where others can come on and talk about it, to have these conversations so we can heal and come up with solutions to create a better society, a better world, and also to free the innocent. So thank you for joining us. Our mission statement here at Turning a Moment into a Movement is to bring awareness to the wrongful conviction of Gerard Haycraft and all others who are wrongly convicted, over sentenced, mentally ill, and medically frail in our community, to inspire, organize, and educate all communities about the need to disrupt systems, policies, and patterns of the criminal legal system that leads to wrongful convictions. So thank you for joining us this evening. We have some awesome guests. We're going to talk about ineffective assistance of counsel and what it is, how it leads to wrongful convictions, and some solutions to maybe help those that are impacted by wrongful convictions. So first we're going to let the panel come on and introduce themselves, and then we're going to bring on our guests, and then we're going to get into the conversation. So first I'm going to bring on Reverend Tia. Hey, Reverend Tia.
Well, hello. Good evening, everybody. Happy Friday. Woo, woo, woo. I'm so excited to be here tonight. And Jay, this is a wonderful, delightful conversation that we're going to have today. And I'm praying and knowing that the education from tonight's discussion is going to permeate and help a lot of people. So I am the founder of the Choice Zone, where I help to empower, educate, and encourage everybody to access your own divine potential. And I know that you have it in you. Wherever you go, you are the fullness of who you are supposed to be. And it's just grabbing that from the inside and being all that you can be for yourself first. Yeah, you count. And so I'm also part of the G100 Michigan chair, Oneness and Wisdom all over the world. So if you're interested in empowering other women, get in touch with me, Michigan Coalition for Human Rights. If you want to become more active in the human rights side of things. And I'm telling you, everybody who comes to this platform, we have joined together on other platforms to get things accomplished, to make sure bills get passed. I am a minister at Transforming Love Community, and I am so excited to be with you tonight as we walk this path together. Jay, thank you. Thank you for being who you are, and thank you for allowing me to walk with you. My life has forever been changed because of Gerard, and I want you to know that. I appreciate you.
Yes, Reverend Tia, and we had an awesome time this past Sunday. Reverend
We did.
Tia is now the co-chair for the Michigan Coalition of Human Rights. Yeah, Reverend Tia,
Thank you.
and Allie, who was with us. She got a really awesome award, and it was just a great night, very empowering. I'm so
Thank
glad
you.
that
Yeah,
we.
that was it. It was wonderful, wasn't it?
Yes,
43 years of coming together and collaborating. That's what they do. We collaborate with other organizations to help stand in the gap and bring about the change that needs to happen. And Allie did wonderful as the Youth Activist Award for this year for 2023.
yes, and
And
it was so awesome.
Aaron Keith
Yeah, oh
was
yeah,
the speaker. Oh my gosh, she was awesome.
she was
She was
awesome, you
awesome.
guys.
Yeah,
She's from the Detroit Justice Center.
yeah,
She's bad. She's a bad sister. And
yeah,
it was also awesome to see the young people that are getting involved in the movement
mhm, yeah, yeah.
from the university. So yeah,
So yeah,
thank you, Reverend Tia.
and thank you. I'm excited.
I am too. I see
Mhm.
Attorney Mack is in the room. Greetings, Attorney Mack.
Well, hello, 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 my sisters and all the good people. Much love and respect to everybody. How are y'all doing? Oh,
How
my
you?
beautiful Black ebony women. Oh, my goodness, I'm going crazy up in here. So it's a beautiful thing to see. Oh, my goodness. So, so yes, yes, yes. Well, so glad to have this topic, and people might think in my profession, I'd be a little bit nervous about that sort of thing, because that's the fox bringing attention to everybody, a bunch of chickens, But I'm gonna tell you what, I love the discussion of ineffective assistance of counsel. It's a discussion we need to have, and it's a discussion that more members of my profession need to voluntarily bring up. So, J Love and Reverend Tia, I'm so glad to be here so we can have a discussion about this. Understand that maybe some other members of my profession that are joining us. So the more the merrier, the better. And so we all have our perspectives on it. So Dr. Hugo J. Mack Esquire, at your service as always. Proud to be here with you. And one of the only people, and I say the only person of the 46,000 members of my profession, with the possible exception of the people who will be on here tonight, who did not parachute from heaven to be with you here tonight, but a man who came up from the bowels of hell itself through the blood of God and Jesus Christ to be restored to my profession. Having endured a wrongful conviction, the loss of my law license, come back to regain my law license and rededicating myself now to exactly the cause that our leader, J. Love, has spoken about. Because I understand quite personally what it's like to be held account for a wrong you didn't commit, and to have to come to realization that God knows, that God knows, that God knows. So I'm very happy to be a part of this great group and to be with my colleagues, and I tell people I may be the only attorney in the state of Michigan, office hours from 8 p.m. to 6 a.m. Monday through Friday, and so 5 p.m. to 4 p.m. on Saturdays and Sundays. But that's okay. Because, J. Love, as I've always said, a lot of my clients don't drive fancy cars over bridges. A lot of my clients live in shanties under bridges. Okay. So, it's one of those situations where, I'm proud to be with them because, those are the people that are written off by society. And let me say this. You have these groups dominated by, quote unquote, the majority culture who say they're for women's rights and these things like that. But the problem with some of these individuals, people of privilege, I might add, is that, today it's addressing the plight of poor Black women. Next week, it'll be saving the whales. Okay. You see, so we have a systematic problem with people that we align ourselves with. We should not have, as a Black community, a progressive community, any permanent friends, but permanent interests, you see. So I always marvel at how many people rally together to put a woman's right to choose in the state constitution, okay? Well, a wonderful, appropriate thing. But we certainly couldn't get that kind of support when we wanted to fully address the restoration of good time, you see, and the end of truth in sentencing. So if all these individuals are truly with us, then I just ask we, in a progressive way, encourage them, well, be with us all the way, not just when it's something that is primarily you want to address for the moment. So now that I've said that, J. Love and Reverend Tia, and I hear that snickering, J. Love. I hear that snickering. So now that I've said that, y'all, here we go. If you find yourself on Trouble Boulevard, push, pull, drag that hoopity to Mack Street. Mack Street. When you're there, park in my virtual underground garage. Oh, and let me clear up something in advertising here. I've never said I have valet parking. I said I have alley parking. So I want y'all remember that. Park in that alley. It'll be safe for a while. We ain't had no break-ins in 2 or 3 days. So I want y'all to know, when you're a people's lawyer, you got to go where the people are. So when you at my virtual underground garage, call 734-239-3118. The Freedom Line. 734-239-3118. The Freedom Line. 734-239-3118.
The Freedom Line.
Freedom Line. Because, J. Love, as you, Mr. and Miss America, and all ships at sea have come to understand, hmaclaw.com is your hookup. hmaclaw.com is your hookup. hmaclaw.com is your hookup. And J. Love, every superhero needs a theme song. So in this here, while I do the boogaloo, I'll be playing for you our rendition of Return of the Mac. And introducing for some and reading for other, our newest Janice, the Janice. And no performance will be complete without Pulp Fiction and the aid of my singing sister, Reverend Tia Livinjohn, the Batman. Thank you very much. Thank you very much. J. Love, it's always important to give the audience opportunity to write these things down, J Love. And J
Yes.
Love, I just want to say this. Ladies and gentlemen, you done tried the rest. Now come on with the best. Okay? See what I'm saying? And now if you don't want to win, please don't come in. And see, J Love, I want you to understand something right here. Now, for all the haters out there, and I know J Love, you're very kind. I know they writing and putting note all on your car, stopping you on the streets and all that. I know who they are. But like I said, J Love, I got a message from them from my late cousin Bernie. I ain't scared of none of y'all. So you see, so that's what I want people to understand. All you haters out there, and J Love and Reverend Tia, I just got to say something. All these people coming up to me smiling in my face, all the time wanting to take my place, on the platform. Damn backstabbers. And see, and part of it, J Love, I got to confess this. This one particular guy, I keep getting all these visits from this guy who's supposed to be my friend. And I'm going to tell what he's doing to me. He come to my house again and again and again. Now, I think he there. He trying to see my woman. You say why I say that? Because J Love, I don't even be home and it just keep on coming. Now, J Love, I don't want to hurt nobody, but y'all help me because I got to get on the right track. I just want to take some of these damn knives out my back. And so this is the problem that we have, J Love. So I want you to know. And J Love, I just want you to say, understand one thing. If the point ever come where you feel weak and the pressure is coming on you, or they trying to slide money in your hand to kick me off the show, all that kind of stuff, I realize these things are possible. I just want you to remember the words of the late, great Otis Redding. J Love, Reverend Tia, I've been loving y'all too long to stop now, J Love. You see, I've been loving y'all too long to stop now. So, J Love, I just want you to know that if push comes to shove and worse come to worse, please remember the words I will tell you of my friend Morris Day in the time. Okay. J Love, for me, ain't nothing worse than rejection. J Love, rather than kick me off the show, I feel a little bad if you just slap my face. So it's one of those situations, J Love, that I want you to understand that I love you. I love all y'all. And I will say this, J Love, I know people ask you all the time, J Love, that crazy attorney is on there. Do you really be mean all that stuff he's saying? I want you to know. You're damn right I do. And I fully endorse this. I fully endorse this announcement, every bit of it. So, J Love, in conclusion, I'm going to say this. This announcement is brought to you out of love and public service by Dr. Hugo J. Mack, the one true king of Russia, Scotland, and Lower Harlem. I love you.
Attorney Mack, everybody.
Amen.
Thank you, Attorney Mack.
Much love. Much love.
I'm going to bring on Attorney Pay. Hi, Attorney Pay.
Okay, why do you have me following that? What the hell am I supposed to say? I'm signing off now.
Good to see you, Counsel. Good to see you. Great to see you.
Great to see you too, Attorney Mack. It's really great to see you. Oh Lord, we're gonna be live today.
Yes,
live and in living color.
You see, Attorney Mack, he sets the bar up high.
Yeah. Really high. Really high. Yeah. I by the way, that people have stolen our thing about brother and sister-in-law. They got these podcasts on now called Sisters-in-Law and stuff like that, right? They stole our stuff, Mac.
Wow.
So
wow.
I don't know. We may have needed to copyright that and have some.
That's right.
But at any rate, we only copy the best. So
yes.
So you're the first person that called me your sister-in-law, and I loved it. So it's good to be here. This is tonight's topic is very near and dear to me. as an indigent defense attorney, I got that calling, Attorney Mack, a long time ago. I realized at a very, very young age, after being a victim of Brown versus Board of Education and having to leave the warm love and caring of a Black school with Black teachers that loved me and cared about me and wanted me to learn and grow, and go to a all-white school and be the only little Black girl in my class. But the Lord had figured out that I had to go through some things to understand some things, and that I needed to endure some things to understand people that were enduring things. And so I did. It was horrible, and they were calling me nigger from the room. But I did think about something during that period of time. And that is, I was really, really impressed that a colored man could change how we go to school in a whole country. I thought that's the most powerful thing I'd ever seen as a little 7 and 8 year old girl. And so so I decided then and there that I was going to be a lawyer, so I could change things and I could be a change agent too. And I ran towards that. I never thought I was going to be anything but a lawyer. That's all I wanted to do. And so I was waylaid during my early years. I met this guy in college and fell in love and got married and all that. And he happened to be a basketball player, and so he got drafted after college and then eventually went into coaching. So I was following him all over the country. But eventually I stopped and I went to law school and I became a lawyer. So but I didn't realize that I was going to be an indigent defense attorney. I thought I was going to be a civil rights attorney like Thurgood Marsh. But my third year of law school, I ended up doing an internship at the Juvenile Justice Center in South Bend with the indigent defense attorneys. And I was home. I said, this is where I belong. I loved it. And I loved doing what I was doing. And I came out, and that's what I determined to do. My husband said, how much money does an indigent defense attorney make? I said, I don't know, but that's what I got to do, because that's what God purposed for me to do. And one of the things that I've learned is that because I was always focused on my purpose and running towards my purpose, it kept me out of trouble. And that's what I try to tell my clients right now. What is God? The reason you sitting here in lockup is because I ask them, why are you here? And they usually say, I don't know. Or they usually tell me the circumstances of the case. And I say, that's not what I mean, why are you on earth? What are you here for? And they don't know. And I said, that's why you're here. That's why you're sitting here in lockup. And the minute you figure out your purpose, you're going to start running towards it. And you will no longer be sitting in lockups. You will no longer be waylaid by all these other knuckleheads that are trying to get you to do wrong. You're going to run towards your purpose and do right. And God placed it in each and every one of us. And he put a passion for it in us. And so I've run towards that passion. And so one of the things that I realized that I could be a change agent in is working towards injustice. And I love doing it. I love doing it every day. I'm old now. I should be retiring, but I still kind of hang in there and do it because it's important. And because I love helping people figure that out. So I'm so happy because ineffective assistance of counsel is huge. And it's a huge reason why a lot of people are sitting in prison. A lot of people have felonies on their records that they can't get out, can't get off, that they can't put behind them. The importance of pardons and setting aside convictions. It's so important. And so I'm excited to talk about this tonight because I think that that's one of the injustices that a lot of attorneys, Attorney Mack, a lot of attorneys do. We look the other way when
That's
we.
right. That's right.
Not.
That's right. That's right. Yeah.
Thank you, Attorney Payne. And I'm going to bring on our other guest. Hi, Mr. Abdul.
Hello.
How are you? Introduce yourself.
Hi, Tia. Most people know me as Roberto, my Muslim name, Abdul Hakim. I've been a paralegal for 28 years. Most of my work is primarily in the area of employment and labor litigation, but I have dibbled and dabbed in some criminal appeals recently, and so to enhance my experience. So I think today's topic is an interesting one. As Ms. Payne indicated, there's a lot of ineffective assistance claims that contribute to wrongful convictions. It's not just police misconduct and prosecutorial misconduct, but it is a steady problem where when you look at these cases, you're like, wow, how did the attorney miss that? Or how did the attorney miss that key evidence in the file and stuff? So I'm ready to roll.
I know you're ready. It's interesting that we're having this conversation. Me and Mr. Hakim, we always have sidebar conversations outside of Facebook posts and everything. And he brought this to my attention about it. And I was like, yes. And as he was talking, I remember my journey with Gerard and how the lawyer just seeing that he had at that time just was really out of sorts. She was everywhere. And so I was doing a lot of running and getting paperwork and all kinds of stuff trying to help out in this case. And so I know that from listening to other stories, and even as we talked last week about Philip Payne's story and the other wrongful conviction stories that we've been talking about, a lot of when you hear these stories, we hear so much about the police, we hear so much about the judges, but we also hear stuff about the attorneys, but I don't know if we turn that part off because we're so focused on the police and the judge and the prosecutor. We're, those two items that we always really focus on. But the defense attorney, I think that, this conversation will help a lot of people that are on this journey and maybe give them some tools that they can use as they look at the attorneys that they're working with. And hopefully this will help people gain their freedom from this conversation. So, Mr. Attorney Hugo Mack, you can take the floor.
Well, okay. Well, first of all, once again, I'm so glad to be in a beautiful group of people on this topic. But let me say this for full disclosure. For 12 years, I was a public defender. The last 2 years of my career in that office, I was the chief assistant public defender. So my job in the last 2 years of my employ with the county was to train lawyers, train public defenders, And one of the things that I would emphasize to them is that the analogy, when a person is drowning, when a person is drowning, they will grab at anything that they can to try to save themselves. Self-preservation is the first law of nature, and that carries over into a criminal case. because, as you know, unlike a civil matter, a criminal matter will allow you not only to be put in jail or prison, in some instances, it will demand your life itself. Okay.
Mm-hmm.
So one of the things that I trained my staff in is the fact that when somebody is convicted, there's a whole panoply of appellate issues that always come up. 9 times out of 10, one of those is going to be ineffective assistance of counsel. Okay. And so that's just a reality that I had to train my staff in. So, I mean, I guess I want to start out by making my background very, very clear in some of my experience. And so in the cases that I supervised and would review these cases where ineffective assistance of counsel allegations were made, 99 out of 100 of them were invalid in my experience. And they were really put up in terms of appellate review because, like I said, a drowning man or woman will reach for anything possible to help them. Okay. So, but now having said that, and I take pride in the attorneys that I trained, top-notch people, tremendously overworked, but nevertheless top-notch individuals. But having said that, one of the problems in the system is the underfunding of public defenders and societies like them, and the ability to retain staff. Because, you know, in this profession, people are looking, by and large, unless you're a true believer like my sister here and myself, they're looking for a path up, you know, and that path up is tied with money. And the higher you get with money, the fewer indigents you see. So part of the problem was in paying people to be able to keep them in and keep them dedicated. But for example, in Washtenaw County now, they pay $150 an hour for they have the assigned counsel system now to handle conflict cases with the Washtenaw County Public Defender's Office. Now, some people will say, well, that's good. And sure, that's fine, paying appointed counsel more, but it's not just a matter of money. See, that's one thing I want to get across here.
Right.
The discussion might say, well, we need to pay people more. Well, yes and no. It's not a matter of money. It's a matter of dedication to cause. Okay. Mm-hmm. Because you can still run somebody through a grist mill getting paid $150 an hour just as easily as you run through a grist mill getting paid $75 an hour. See, so that's not the issue. Or $250 an hour. That's not the issue. Throwing money at it is not the absolute answer. So what has to happen is that we have to reinvent and reinvest in a group of lawyers. You know, I'm almost 70. I'm hanging here as long as I can, but God has got a time for me to be on this earth and time for me to leave this earth. So my thing is to try to train as many young lawyers coming up as I can to take my place. And my sister counsel knows that too. You know, we won't be here forever. So, you know, somebody's got to be able to come in and fill. So hopefully in the discussion, we will talk about the need to pass the baton. And frankly, I don't see a bunch of baton passing. I really don't. I don't. So that's my initial take, J Love.
All right. Hi, Kevin. I wanted to say hi to Kevin before we get started. Hi, Kevin.
Hello, J Love. How y'all doing? How the panels? How y'all doing? All right.
Kevin, just briefly introduce yourself. Kevin. Go ahead, Kevin.
My name is Kevin Haynes. I'm a prison activist and advocate. I've done 27 years in the federal system. I'm a paralegal. I've had the honors of teaming up with the Honorable John B. Gleason from the Eastern District of New York. Spoke at Harvard, Yale, NYU, American Bar Association here in New York. And regarding prison reform, ineffective assistance of counsels, and different other things. So it's an honor and a privilege to be in here. Thank you.
Thank you, Kevin. Kevin, I just saw that New York signed the bill today for the Clean Slate Act. Yay, welcome. Welcome, New York. Okay. I have this that I saw online, and this definition when I was looking this up, you guys, to have this conversation. And it said ineffective assistance of counsel is a legal term that refers to the failure of a defense attorney to provide adequate representation to their client. The Sixth Amendment of the United States Constitution guarantees the right to representation by an attorney in a criminal case, but it does not guarantee that the attorney be effective, thorough, or competent. So when I read that, I was like, okay, it just means that you can have an attorney. It doesn't mean anything. So with Attorney Matt, when you just said about, money, you can pay a lot of money, tons. People have paid tons of money and didn't have an outcome that was great. So you're right, because the Constitution doesn't, say, hey, you got to be smart. He just got to be an attorney, I guess, or that's just your right to just have a license.
But J Love, I would like to ask, where did you find that at? Because that negates the Supreme Court standards of attorney called Strickland versus Washington, as well as Ron Paula versus Beard. In Strickland versus Washington, they specifically quotes the American bar, the ABA standard of what they deem that attorney supposed to do. See what, and that's by the Supreme Court. See, what the Supreme Court do is their job is to interpret the Constitution. So although that may say that regarding the Sixth Amendment, according to the Supreme Court, there's a two-pronged test regarding ineffective assistance of counsel. So that's not necessarily factual. And they quote the standards under the American Bar Association right there in that case that they supposed to that governs them, that they supposed to go by. So no, they are supposed to be effective. They're supposed to do investigations. They are supposed to follow leads. They are more than just a bunch of bodies that's just standing there in court. There's more to that than just that statement.
Right. I was going to say that the Sixth Amendment, part of having a fair trial requires effective assistance of counsel. You can't possibly have a fair trial without it. And if in the Strickland test does require that the counsel is reasonable. It doesn't require us to be perfect, but we are required to reasonably represent our clients. And if it's if our performance prejudice the defendant, which means that they couldn't get a fair trial based upon our performance, then there are good results that can occur. Their convictions can be overturned. They can vacate their sentences. So it's important that we effectively represent our clients. And I there are a lot of ways, and we can get into this later, that counsel gets around that bar, that reasonable bar. There are ways, but we are required to operate under ethical standards and court rules. We're required to provide reasonable and effective counsel at every stage of the process, from the arraignment to all the way to the post sentence. So I know that it's interesting because indigent defense attorneys are busy. They pile a lot of work on indigent defense attorneys, and with very little help. I think that's changing now with MIDC standards, but we should put enough pressure on the system to require it to back us up and help us to be as effective as we possibly can. We're fallible, and like doctors, what we do, our mistakes impact our clients. And they're dire consequences. You know that, Jay. You know that, Evan. They're dire consequences when we make big mistakes, or even sometimes what seems to be little mistakes. If we don't file a motion, if we don't make demands on the prosecutor to turn over all of the evidence, if we don't follow up and make sure that if they give us edited videos and our client is telling us, no, that's not all of it, it's our responsibility to go in there and fight for that unedited video, and call out concerns to the court about conduct. There are all kinds of ways that we can fight for our clients and provide them effective assistance. And I know that so many attorneys do the minimum, and they file the motion, but they don't fight for the motion, or they accept plea deals that they know they shouldn't accept. And it's easy. It makes it easier. You can pass the case along faster, and it may not harm the client that much at that point in time. But that stuff can come back and bite somebody later in their life. And so for me, the ideal is a not guilty or dismiss. I mean, that's the ideal. But I know that there are circumstances that we're not going to get that. But we can do the best we can to get the best we can.
Mr. Abdullah?
Yeah, to add on to what Ms. Payne said, yeah, the attorney has a duty to use reasonableness. You're not entitled to a perfect attorney, but you're entitled to effective assistance, which requires counsel not to ignore exculpatory evidence, not to do reasonable investigations, not to pursue exculpatory witnesses. You have a duty to listen to your client. You also have a duty not to do anything unethical that your client asks you to do. But I have seen cases where an attorney's busy. Your right to effective assistance of counsel should not yield to the attorney's workload. And I have seen cases where paid attorneys, set aside for the moment that how busy the indigent attorneys are, I have seen where paid attorneys didn't even do the minimum required. I mean, it rises to a shocking level. I'm nobody but a paralegal, and then when I get the file for appellate review, I see stuff in the file like, wow, how did they miss this? And even though I'm not the defendant, I don't want to hear how busy you are, because guess what? The burden gets higher when you go up to the Court of Appeals in the Michigan Supreme Court, because you know what they're going to say? Sound trial strategy. You have to show it is a very high burden to meet. And also they're going to put the blame on the defendant if your attorney skipped the beat. And your attorney's got paid and he's going out the back door, and you're convicted because they slipped.
Yeah.
And you want to tell me about how busy you are? Do you want me to hear that when my freedom is on the line? I don't think so. But on the other hand, I do understand how busy attorneys are. I'm busy. I mean, it's not an easy practice. And there's a lot of things I love, and that's one of the things I hate about the criminal profession, is that people don't, the Sixth Amendment, it rings hollow in real life situations. People are convinced or sweated to plead guilty without the attorney mounting even a minimum challenge to the evidence. I'll give you a perfect example. We have a case where we got a remand from the Michigan Supreme Court recently, and guess what was in the file? A second statement from the key witness that said he didn't know who the killer was, but his first statement identified our client. The attorney didn't challenge that, didn't impeach that witness at trial with that statement. This is one piece of document, and you want to tell me how busy you were? Because and sure enough, the Supreme Court was convinced that that was damaging evidence, that was ineffective assistance, and sent it back. I mean, if we found it in the file, it makes you wonder, how did the attorney miss this? Because it was in the homicide file. And so there you have it. And it's not just the indigent defense system. Like I said, I've seen cases where with paid attorneys have, and I don't say they do it intentionally. They are too busy, but the defendant doesn't want to hear that. You knew you were busy when you took this case. Mm-hmm. So that's my take on that.
Yeah, and I always wonder, how does a person prove that the counsel was inadequate? How do they prove, what conditions make it so that, in do an example, how can somebody prove, how long does it take to prove that, that they did not have or perform in a way and utilize the correct investigative techniques, or that they also because of that loss, because they were inadequate, that person was judged wrongly. Mm-hmm. And how do you prove that? What can we tell the people watching if they've had this done? What's the next steps?
Well, you have to show prejudice, right, Ms. Payne? You have to show that for counsel's errors, the result of the proceeding would have been different. What that means is, like the example I gave about the second statement in the file. Had the witness been impeached with this statement at the time of trial, there is a reasonable probability that the jury you could at least get a hung jury. You don't have to prove all 12 jurors would have found you not guilty. So it is a high burden, but hopefully you have some concrete evidence, but you cannot be dissatisfied. Well, generally, Ms. Payne, you help me here. If it's trial strategy, it doesn't always mean that it's ineffective assistance. Your attorney may have a good sound trial strategy, although you may not agree with it. The appellate courts give high deference to that type of stuff. But where there was exculpatory evidence, there were witnesses who weren't interviewed. Had they been interviewed and brought to court to testify, you can still argue that could have been sound trial strategy, but it gets close, right? It gets close to a showing of ineffective assistance.
That's the defense for counsel who are pulled in front of the bar for ineffective assistance of counsel. It was trial strategy. That's what everybody always says. And it's very difficult to overcome. It's very difficult. And I know people sitting in prison right now that, but check, here are some things that I've seen happen. I've seen attorneys who are high or been drinking and sitting in trial, nodding off and going to sleep. Mm-hmm. The defendant needs to say it right then and there. Your Honor, my attorney is nodding off and going to sleep, or I can smell liquor on my attorney's, breath, or I think my attorney is high. I need him to be tested, or something. You need to be bold enough to say it, and stop the court and bring it to the court's attention right then and there. Because if you don't do that, and appeal, you can't prove it.
No,
at that point. And so I've seen it happen. I've seen appeals, where it was too late, and it didn't get remanded. I've seen attorneys actually not introduce evidence that was exculpatory and say it was a trial strategy when it's brought up on appeal, and they overcome that ineffective assistance. So the appellate court gives a lot of latitude to trial strategy, and sometimes to the detriment of clients. But sometimes attorneys won't argue something because they think it's there's no point, but whether you think there's a point to it or not, you ought to argue. You got to make the argument. The last case I had that went up on appeal, we won, and the appellate court remanded it back to the trial court because the appellate court actually quoted me and adopted my argument, and nobody and everybody thought it was ridiculous, but it wasn't, because you have to say it. You have to at least make the argument, no matter how crazy somebody thinks it is. So we have to be cognizant of what the damage that we do. And I have a son in prison, and I know the damage that it does. And I know that kind of thing victimizes families. It victimizes the defendant's families. It victimizes the victim. It re-victimizes them, and it's damage to them because they want justice. That's what they want. They don't want people who didn't do it to go to prison and be held accountable. They want the people who did it to be held accountable. And it's up to all of us. And I know that sometimes you have to fight the prosecutor, you have to fight the judge, you have to fight everybody. But that's what I like to do. So
yeah.
So,
J-Love, if I could put this point in, there are some avenues that criminal defendants have in terms of ineffective assistance of counsel. In 1973, the Supreme Court decided a case called People versus Ginther. Okay, and so what a Ginther hearing is where let's say you're convicted, and you're telling the judge, look, judge, I had ineffective assistance of counsel, this and that. And so getting that hearing, where they'll bring the attorney in, okay, and ask questions about, how did this happen and what have you. So most of those hearings are horrendously unsuccessful. Okay, but there are cases where some vindication occurs. But I'm just letting you know, as a practitioner and as a person who trained defense attorneys, horrendously unsuccessful. And I'm not saying that that's right, but I'm saying the way the system is set up. So you gotta understand something. And I know I'm probably largely preaching to the choir here. This is a systemic situation we're dealing with here. You need to understand that. So the issue of ineffective assistance of counsel is just one brick in a wall. It's just one brick in a wall. Because let's say you were able to knock that brick out with a sledgehammer, the wall is still there. Mm-hmm. Taking that brick out that brick is not the cornerstone of the system. No, it isn't. So what that means is, if you knock that brick out, in other words, let's say you eliminate ineffective assistance of counsel altogether, it no longer exists. The wall from wrongful conviction and over conviction is still there. Mm-hmm. It's still there. So all that means is a little bit of breeze can get through that space where that brick was. A little bit of breeze, but that's it. Ain't no tornado, ain't no hurricane coming through that mother scratcher. It's just a little bit of breeze, okay, coming through that. And you got a whole bunch of people trying to get to that breeze. I know I was. So. Hey, brother man in the corner know what I'm talking about.
Kevin. Go ahead, Kevin.
So what I'm saying is, at least that is a venue, okay, where you can put forth that and maybe help create a record, you know, an appellate record on that. But, you know, you've got to really be aggressive and proactive in that, and start making, like someone said earlier, complaints about, look, Judge, I asked my lawyer to get Mr. Jackson subpoenaed because I know he was in the area and he knows that this didn't happen and my lawyer didn't do that. So one of the things we've got to do, which is one of the reasons I told you about that book from 2012, is to educate people from the jump street, you know, before they get into the system as to what their rights are, you know, so at least they can be somewhat educated before they go into that battle.
Yes, Attorney Matt. Go ahead, Kevin.
Basically, Reverend T had mentioned a thing about the indigent person. What a person can do first and foremost is obtain any and every sheet page of documentation, motion that was filed into the court, transcripts that was filed into the court, hearings that was filed into the court, comb through them. That's first and foremost. Second, they're going to start writing for FOI. This way, this will, once you obtain, because you don't know what's in there, once you obtain this evidence, that's newly discovered evidence, there's different things that can be proven to fortify and strengthen your ineffective assistance of counsel argument. So that's what you want to do. This anybody can do this. This is for the poor man and the rich man. A lot of us don't have money, so therefore we stuck with these public pretenders. So that's what you can do. Get all your paperwork. That you got to get all your paperwork, all your documentations. Second, start writing the Freedom of Information Act and different other places that you know, and see if you can get statements and because you want to accumulate everything. For the guys that just came in, you want to build a record. You want everything to be on the record. I don't care how stupid or silly it sounds. You want to establish a record because the courts has been having a habit now to saying if you didn't raise it back then, you can't raise it now. Another thing that's damning and prejudice. The attorneys need to start looking at these guys' warrants when they first came in to the time they get indicted. Because a lot of times, if you don't move for a dismissal of the indictment before the person's convicted, they ain't trying to hear it, and they got Supreme Court case law on it. You ain't gonna get that overturned. I'm a victim of that. I'm a victim of that, of being arrested illegally, being held illegally. They lied and said that they had warrants and stuff, and there was never nothing ever filed. My law, and I paid for this attorney. So yeah, went right on through the system, got convicted, and then I didn't raise it on my habeas because it's already a rule in the Supreme Court. If you don't raise that issue before your conviction, before you go to trial, then you hit. So this is very, very, very important to any and all. Read page by page, not just something they put up there. See if they actually have those documents. So that's something that's very important. And plus, another way that they get over on this ineffective assistance of counsel is one of the most disgustingest words I think I ever heard in the judicial system. It's called harmless error. They're saying it was a constitutional error, but it was harmless. And you might have 1,000 different harmless errors, constitutional errors, but they say it's harmless. It's like getting slapped in your face 1,000 times until you become comatose unconscious. And right before you hit the ground, they punch you and say it was the punch that did it, as if those 1,000 slaps has no effects on you. And they call it harmless error. So this is why I'm big on transcripts. I'm big on accumulating other evidence. you know, and get it all together. So this, when you do file a thing regarding ineffective assistance of counsel, your odds of prevailing is higher. One thing that they have been big on lately is investigations. So if you can really prove that this investigation would have been a linchpin on the jury, reasonable jury may say guilty or not, then yeah. So that's my take.
What is a harmless error if you end up in prison?
That's their way of negating your constitutional rights.
Yeah.
That's their way of saying that we're not going to give you the relief. It was an error, but in light of everything else, and what they say, this their favorite word. Oh, the government or the state, the government has a very high burden to overcome. So in the light most favorable to the government or the prosecutor, we're gonna find him guilty. And what they did was harmless error. It was a constitutional error. They denying it nonetheless, but they saying it was harmless. This is why I'm strong on like getting documents, person combing through the transcripts, anything to try to, you got to fortify this thing. So you know, it's all a crapshoot, but you got to fortify this thing so the odds will be more so in your favor than against you.
So, Mr. Hakeem, do you see that question down there? But Deidre Grayhouse said the FOA gets denied, stating can't locate files in Detroit. Attorney needs police and prosecutor files to compare our files.
You know, that reminds me of a FOIA battle I had with the Detroit Police Department. It was about 10 years ago. And they told me they didn't know where the files were. Not unbeknownst to them, I know that they archive old files off-site in Canton, Michigan with Iron Mountain. I called Iron Mountain, sure enough, they gave me the box and the shelf number. So if I could find, if it was that easy for me to do it, city law department, you could have done this. They can find these files. I mean, they find them. They recently found a file in a wrongful conviction case, and the guy was up for hearing. The homicide officer, was a year ago, you guys probably heard it on the news. He walks in with the file. They found that file real fast because he's you know, things were looking good for him. He might get a new trial. So also during COVID, they were trying to use COVID as a reason not to turn files over, but I got the file because I told them I'm not trying to exchange blood. You can email me the files. You can send them by email. Don't tell me you can't because you did it pre-COVID. So what's the difference? Well, people are working from home. Well, just get one officer and go to Canton and get the file. I mean, there's ways to go about doing this, and unfortunately, they do exploit and prey on people not knowing, you know, how to battle with them. But yeah, I don't buy it. It's inexcusable. It's just it's wrong. And you know, you have some remedies under FOIA which aren't much. You can get like $500 in damages, and you have to sue them to enforce compliance. And by that time, all that happens, they're going to turn the file over to you. One of the things I want to add about this harmless error, the way I understand it is, and I very seldom defend the courts. I like it and I don't like it sometimes, but it makes sense theoretically. Because sometimes what they do is the balancing test, the appellate courts, and they say, well, yeah, okay, this new evidence, but against the untainted evidence that came in at trial, like if there's some DNA that shows you still committed the crime, they say, well, no reasonable juror would even find him guilty with this new evidence. So what is it fair? That's a matter of debate. But the way the harmless error works is if there's some untainted evidence on the record that still points to your guilt, good luck. Michigan, now that we're on the subject of ineffective assistance of counsel, you have to show deficient performance and prejudice, right? So prejudice is you have to show that, but for attorney's errors, there would have been there's a reasonable probability that the result would be different. Prior to 1994, you didn't have to show prejudice. So it was sort of like what they call a structural error. Certain constitutional errors are structural error. And what that means is you get an automatic right to a new trial. In 1994, in the Pickens case, Michigan adopted the Strickland standard, and they imposed that additional burden to show prejudice. Again, it raised the burden on the defendant. So you have to show a lot more now. And again, it's not just enough to complain about your attorney's trial strategy, because you're very likely going to lose on that. Your attorney, their performance has to be objectively unreasonable. Like there's so many examples, I mean, but other than challenging their trial strategy, you've got to be careful with that.
Yeah.
Attorney Payne.
Well, I certainly agree with that. I think that one of my biggest problems with well, recently I got a call. I had a client some years ago, 10, probably 15 years ago, and there was an exoneration officer calling me from Detroit, and he was here because he understood that some misconduct had occurred in an investigation, and he wanted to know if I knew. He said that my client said that I had evidence of that, and that there was some discussion about this in the background. So I told him, I said, yeah, I do. And they said, well, they can't find any of this evidence of misconduct. And I said, I have the audio tape. Would that be helpful? Because I'm a pack rat. I keep everything, and so he got so excited. And he and I were working together with this, but you have to have somebody like him that was really committed to making this happen. And most of the time it's families that are working to go through the documents or to make demands on the system in order for an appellate attorney to use to get a hearing. But here was a guy. He was an officer. He was out working out of the prosecutor's office in Detroit. I got so excited. I said, "Oh, let me go to my storage unit. Let me get, but those kinds of things are important. And so, but that fight is, well, Kevin knows. I know, Kevin, because you were speaking my language when you started talking about, the harmless error. It is true. It is true that it does raise the bar for defendants. Everything makes it harder for the defendant. And so, unless you're a privileged person, and then it's not so hard for you. But for most of us, it's very difficult for the defendant. And I think I want to bring up now my biggest problem right now. And I want to know if any of you have run into it. I'm running into so many clients who don't have the capacity to stand trial. They shouldn't be, but the forensic unit is not sending back. It takes forever to get us an assessment, and then the assessment isn't well done. And most of the time we don't have a way to fight that. I mean, the court says, well, the forensic says that they're competent, they're competent. And they're not, sitting down talking to them. They can't help you with their defense, and you're that's a very, very difficult fight. And sometimes they're not competent because of the trauma that they suffered. It's not physical. it's not something that you can look at, but the questions aren't asked. And so they emerge from the forensic unit, and they appear to be competent, but they're really not. And they're so traumatized that they can't help you with your defense. It's very, very difficult. One of the things that we are doing in Kalamazoo is our indigent defense firm is partnering with WMed here, and we've got a grant, and we're partnering with them, and we're producing our own competency assessments so that we can come back and fight that, in court. That's very, very important work. If we don't do things to combat how our clients are treated in court, the system, continually working against the system, we can't pull the one brick out. We don't get to punch the one brick out, and the wall just stands and creates problem after problem after problem. So I'm very, very concerned about the level of competence in most of my clients. Most of them.
Attorney Payne, that's big.
It's huge.
Yeah, but that's big what you're doing.
It is. It is. Yeah. I was a founding member of the board of directors for our indigent defense firm, and I've been president for the last couple of years. And we're moving forward. We're doing some good things, but and by the way, pulling up school records don't count. Because when you pull up school records, most of the time you're looking at someone who didn't attend, but you don't look at why they didn't attend. And so those are things that you have to mitigate against the forensic examination and assessment. And so we're mitigating against those. We have social workers that do mitigation reports to combat the PSRs. You have to do that. You have to find a way that mitigates against the system fighting our clients. They just set them up and knock them down one at a time. And so we've got to find ways to mitigate that and to fight that. And so those are some of the ways that we're doing it here. But that's one of the most important things that we can do, because I don't know about you, Hugo, or you, Abdul, or Kevin, but I'm telling you, most of my clients just aren't doing very well. I mean, and a lot of it can be connected to trauma, childhood trauma, whatever trauma,
Yeah, I have seen it become more important with technology and science today for lawyers to get up to speed with the forensics.
Mm-hmm.
It's very important. And give you an example, like prosecutors have a huge arsenal, right? They can hire any and every expert.
Yes.
An indigent defendant, at least in Wayne County, I think this is everywhere, has to beg the court for fees to hire a counter expert. Well, this is supposed to be a level playing field.
No, we don't have to do that. MIDC provides funding for us to do that. Oh. We don't have to beg the courts anymore.
Oh, that's awesome. Because it's a need, right? It's a need with all the science of technology, DNA, cell phone tower evidence. Oh my God, how many cases I see nowadays?
Yeah.
It's like technology DNA. You claim you have an alibi, you were 50 miles away, but they got your cell phone. It's pinging you down the street from the murder. Right. Then the attorney's hands are tied. And I encourage people to commit crimes, but when I read a lot of files, I'm like, why did you take the cell phone with you? Because it pinged you in the area, and now you're arguing alibi. You want to blame your lawyer because they can't undo this. It's like, So, yeah, the technology and the scientific evidence is becoming more useful in courts. And prosecutors, again, they have a huge arsenal. They have the sky's the limit. They have all the money to hire all these experts. And the attorney's jobs is much harder. And later on, you're going to argue ineffective assistance. There's only so much they can do, because I'm going to tell you something. You don't keep your mouth shut. You take the cell phone to the crime scene. And what do you want? I mean, this is not rocket science. And I get upset when I open the files and I see this stuff, and I'm like, well, that wasn't ineffective assistance. They couldn't challenge this evidence. So it's just, it reminds me one of the many things I hate about criminal law, because some of this is common sense. If you're going to commit a crime, the mafia, the mafia would not hire some of these people as accomplices, because we're on the subject of ineffective assistance of counsel, and then you want to blame your lawyer because they didn't challenge the cell phone technology. How can they? That's technological DNA evidence, bro. You said you were in Ypsilanti, you were in Warren, where the murder happened down the street. So, oh God, I can't take it much.
Attorney Matt, turn on your
Sorry.
There you go.
Okay, look. I'm sorry, I'm laughing here because look here. When I was in juvenile court, okay, defending juvenile defendants, right? When I hear these stories, I just got to say this because it just made me laugh. We had a juvenile defendant, right? And so we was having a jury trial, okay? I don't know, he's accused of, snatching people's Halloween bags. I can't remember what it was, okay? And so, we was doing good. We was doing real good. Had everything set up and everything like that. And they had the alleged victim get on the stand, right? And I remember the jury sitting in there. And so prosecutors asking, do you see the person that snatched your bag? Do you see the person that snatched your Halloween bag out your hand, right? And I remember the defendant, having a young black man, was sitting right next to me, right? Now, the victim is looking around the courtroom like he's squinting, right? So he passes, like, you see somebody's eyes pass by somebody and then come back around and pass by again. And so, and the prosecutor saying, now look careful, do you see the person in the room? And he's looking around, and my guy going to talk about, no, it's me, here I am. So he called himself helping this boy out. And all I did was just put my hand in my I will never forget that for the rest of my career. He saw that boy looking around, and he was offended that boy didn't remember him. And so anyway, let's just keep that amongst you and us and the other 3 million people looking at this, okay? So when I hear y'all talk about some people really not doing good, like Sister Attorney and then Kevin and Abdul, you're right. But it started at a young age with them not doing good.
Right. So when we have the Attorney Payne, they have the funds to come in and work with, say, hey, this person is not, okay, which I think is big in Kalamazoo compared to a Detroit. You think Detroit would have something like that in a larger city that would have some kind of program that say, hey, we're going to work with these people. We have the funds, we have grants that we're going to have these professionals come in because something's not right, like Attorney Mack, something wasn't right there. So I'm just saying, you have these professionals on deck. And so when I'm hearing Attorney Payne saying this is going on in Kalamazoo, that they work together and that, they see this as a need, this is something that's real progressive compared to where we stay. Right, Mr. Hakeem?
Yes. Yeah, it like I said, it's very important to meet your opponent's evidence in court. And with this science and technology, I don't envy the attorneys' jobs today because they got their work cut out for them. But hey, more power to you. But I'm just saying, it would help if defendants were more technologically and scientifically inclined. That just understand and appreciate the attorney's job is hard also, and the less evidence, the better. The less evidence of guilt or whatever, the better. Like I said, it's not a job I envy, but I do. I'm a paralegal, but I do it behind the scenes work, and I like what I do. Even though, because you always want to think you're going to win, but even when you lose, you get some reward out of knowing you did your best. But it's never a dull moment. It's never dull.
Right.
Yeah. There are a million stories like that, and sometimes you start examining the competence of someone. Now incompetent does not equal how should I say this? Well, I had a client that the police came to his door, and I've always telling him, don't talk to the police. If police come to your door, don't let them in unless they have a warrant. Ask. First thing you say, do you have a warrant? They say, well, no. But then say, no, you come back with a warrant. I have a T-shirt that says, come back with a warrant. So I get the police report, and he lets the police in, and they find cocaine. And I said, you say, so they asked him, well, why'd you let him in? He said, because the police officer said that accused me of selling meth. He said, and I wasn't selling meth. I'm like,
so I was selling cocaine.
You had both of those things are illegal. You think if he doesn't find the meth, he's gonna leave? Come on, man. So sometimes it's just the way it is, and
Right.
You're right.
But that's not
that I'm incompetent.
right. That's not incompetent. That's just plain old goofy. Because that's like, saying, get pulled over for traffic, and they're saying, well, can I search your car? You got like 10 keys of cocaine in the trunk, and you say yes.
Happens all the time. Happens all the time.
What the hell?
And it's called one of the exceptions to the warrant requirement. And then what's going to happen? Once the defendant is charged, he wants the attorney to, get this evidence thrown out of court. Sorry, I can't do it. They didn't have a warrant. They didn't need one. You gave them permission to enter the home. Yeah. And it's called under the plain view doctrine. The police officer is not required to ignore incriminating evidence that's sitting right there on your table or wherever. The same thing if they'd see a weapon out in the open. This is why do you think when police at roadside stops, first thing they're looking at is
that's when they find the guns.
Right. If it's in plain view, they don't need to go get a warrant. They're going to get a warrant and come back so give you time to destroy the evidence, right? So this is common sense. I hope I don't get charged with telling people how to be criminals, but but again, on the subject of ineffective assistance of counsel, you can't argue your attorney was ineffective because they didn't file a motion to suppress. They know it's not going to be suppressed,
and that's what they always want you to file a motion to suppress.
And you risk getting sanctioned for that, right? Because attorneys then they're going to throw you up at the judge, and no matter how well you break it down and say this is not a successful motion, there's exceptions, and you gave them permission. And the home is a very interesting exception, Ms. Payne. I had a situation like that where the cops came to a friend's house, and they came a second. He didn't let him in the first time, and so he told me about the situation. And he said, "Was I wrong for not letting him in?" I said, "No, were you wrong? No, you did the right thing, because once you let them in your home, especially without a warrant, like I said, they don't need to get a warrant. Everything starts to unravel." And
Yeah.
if you notice, it's more than you notice. It's usually 2 or 3 officers coming. Why do you think it's that? One is going to be talking to you.
That's
The other
right.
two
Probably
looking
only
around,
walking
right, to see if there's evidence, incriminating evidence. And once they're in your house, it's going to be hard to convince them to leave. They've got
Right.
guns, they've got badges. You're being charged. Now you want to blame your lawyer and say you were ineffective because you didn't get this thrown out of court.
That's
No,
exactly
you file a motion to throw it out of court because it's not going to be thrown out.
That's right.
Right.
Exactly.
And we need people to know that ineffective assistance of counsel is a high bar to, prove. That cannot be your only the strategy for appeal. Like, it has to be a lot, and that it can't be just my counsel was ineffective or they didn't listen to me. It has to be more than one thing. And that's important for people to know. And also with the Supreme Court ruling of last year also makes it harder to even bring that back into, ineffective assistance counsel into play. I know we talked about that last year a lot, Attorney Matt.
Yeah, and look, can I just say this also? See,
Yeah.
part of the problem is that the system would break down if every case that should be reversed is reversed. Okay, and so the truth of the matter is that we have sacrificed constitutionality for efficiency. Okay, you see, that's the problem. Because when I hear the folks on this panel talk about harmless error, in the state of Michigan, harmless error is not just a loophole, it's a tunnel. It's a tunnel. Okay, anybody from Michigan knows that, like, they've got a tunnel underneath the water to go from Detroit to Windsor. Okay, it's a tunnel. It's a tunnel. And so the problem that we have is that we don't have the political will, or not enough of us have the political will to elect prosecutors and judges and appellate judges that will say, wait a minute. This is a constitutional violation right here, okay? And yes, I'm going to reverse this case. I'm going to send it back. Yes, we're going to get complaints to the court administrator's office that the system is overloaded, that we got speedy trial issues. Yes. So in order to avoid that, we have gotten very efficient in the state of Michigan. Oh, yes, we have. Do you think it's just coincidental that fewer than 3% of cases that go on leave to the Michigan Supreme Court are granted? In other words, 97% of cases where someone tries to seek leave to appeal, and for those of you who don't know, leave to appeal means you've got to ask permission to appeal. Okay, you see, the Michigan Constitution says if you're in like a circuit court, there's circuit courts, Court of Appeals, and the Michigan Supreme Court. That's the hierarchy in the state of Michigan. So if you go to trial in circuit court, let's say the charge with B&E, okay, and you're convicted, you have an automatic right to appeal that conviction to the Michigan Court of Appeals, okay, which is like a salmon swimming upstream with a 50-pound weight around its neck, by the way, okay? So, and then to try to get from the Court of Appeals to the Supreme Court is like a salmon trying to swim upstream with a 50-pound weight on its neck, and it's got a big dam with no way to get through it. Okay, so that's how difficult it is to get there. So the question that I ask people all the time, and the question I'm posed to you here, and the next time somebody confronts you, are you willing to bet your life and the life of someone you love that the system is that good? That the system is that good? Are you willing to put a gun that has 100 slots for a revolver that's got 100 places for a bullet to go in, okay? And we just gonna put 3 bullets in there. So that means 97 other of those chambers are empty. Are you willing to let me spin that wheel? Okay. Point that gun at you or your loved one's head and squeeze the trigger. Because you got a 97% chance of that chamber being empty. See, when I put it to people like that, they say, hell no. Hell no. I'm not risking my life or my family's life. I don't care what you say, Mr. Mack. Well, I say, thank you, sir. Then why in the world do you think I should remain silent when you tell me the system is 97% good and accurate? Make it personal, colleagues. That's what I do. I make it personal to everybody that I confront on the issue of qualified immunity. And I hope you let me talk about that for a minute, J. Love, because I attended a sheriff's debate earlier this week in Washington County. 3 people running for sheriff, and if not on this show, maybe another show. Got some very interesting answers, by the way. So the system is not that good, folks. Newsflash: the system is not that good.
Yeah. Amen.
It's not equal justice under law.
I would just like to add on to that. Up until 89, almost everybody was guaranteed an appeal, all the way up to the Supreme Court, even on your habeas. The first George Bush Sr. stopped it in 89 regarding that the Supreme Court gets to hear the case. The case could make it up to the Supreme Court. As time went on, the worst president in the history of my lifetime, Mr. William Jefferson Clinton, Bill Clinton, he passed the AEDPA. That was the Anti-Effective Death Penalty Act. And when he passed that, he restricted the habeas.
That's right.
And what happened with that was, this is what Attorney Hugo Mack is talking about. In the feds, we have something called a habeas corpus. It's a 2255. In the state, it's called a 2254.
Right.
All right. So now what they did was they said, once you file to the district court, should the district court deny it, you're not guaranteed an automatic appeal. They tell you under Rule 4, you have to ask that same judge who wouldn't overturn his initial ruling for permission to file it up to the appellate court. This is tantamount to the judge hitting you over the head with the bat. And you asking the judge, hey, Your Honor, can I have that bat so I can try to hit you back over your head with it? What's the odds of him granting that request? That's one of the worst bills that has been, and it was done for terrorists. That wasn't done for terrorists because it only affects the American citizen. So after that, the appeals court, a lot of times they will deny you and say, well, the judge said you didn't, it wasn't reasonable enough, a jurist of reason. That's the language. Houston, Slack versus I forgot the name of the case. The Supreme Court case. They said a jurist of reason wouldn't agree that your case should have been heard over by the appellate court. Then when you go up to the Supreme Court, they're not even, half the time they're not even going to hear it because they've been restricted. So they only hear a certain percentage of what Attorney Hugo Mack is saying. Only hear a certain percentage of the case. So therefore, you stuck. There need to be a show nationwide on that AEDPA. That must be abolished. Because let me tell you the most damning thing about that. They tell each and every defendant that's convicted that they have 1 year to learn what it took the attorneys 8 to 12 years to learn. You got 1 year to master whatever this is that you convicted on, the system. And then what they do, they put a bunch of these procedures up there. And then when you miss a procedure, they got something called procedurally default. This is why ineffective assistance of counsel is so important, because the U.S. Supreme Court said that is one of the only ways that you can overcome. If you miss your 1 year time limitation, you can come back in on the ineffective assistance of counsel. But they don't put so many blocks and hurdles on that. This is why I stress, like I was saying, getting enough evidence and fortifying your case, so the odds to be more in your favor than against you.
Yeah.
Well said.
This is amazing conversation. I wanted to just bring before the viewers that there are ways, and I want the attorneys to chime in on this, because a lot of times people are afraid when they do get counsel. They're afraid of what could happen, and like I always tell people, please do not go without representation. Do not go into the courtroom without representation. Attorney Mack will tell you, I will call him, I call Attorney Dorfine Payne. I will make that phone call before I go anywhere. I will not be alone. And so, a lot of times people need to know that, what about that attorney who makes decisions without you, or that attorney who files notices late, or the attorney who has behaved, I think we had mentioned it before, unprofessionally, maybe coming in high, or having been drinking. And those are just possibilities. Or how about if they're that attorney who doesn't? I had one friend of mine, the attorney wouldn't even talk to her, wasn't responding to her personally, or not handling or utilizing the correct terminology in court, or following the correct procedures. Can you guys give even greater examples and talk about that? Because if we can, in somehow, some way, if they can notice that I'm getting ready to go in this battle and I'm really alone, maybe I need to make a decision now before, maybe change up.
Right.
Yeah. And those are instances where it's very, very important for you to notify the court right away. There are instances where attorneys don't go to the jail to visit their clients, or there have been times when I actually tried to go to the jail to see my client, and the jail said, no, we can't let you in. And the next day I was in court telling the judge, and not only was I in court telling the judge, my client was in court telling the judge, going off. They wouldn't let me see. I heard that my attorney came. They wouldn't let me see it. And the judge held the sheriff accountable. And so, you have to say something. You have to. There are times when clients have to speak up for themselves, but you always have to let the court know. And let me tell you something. Attorneys snap too when they think the client is going to go tell the court. They will respond, and so will the jail, because that's another problem here in Kalamazoo. I don't know whether it is anywhere else, but in Kalamazoo, it's the sheriff doesn't. It's hard. It's really difficult to get in. And they put all kinds of restrictions on attorneys. It's the silliest thing, but so yeah, you have to say something. And I know some people don't know to, but they better go off on somebody, and tell somebody. And the court lets you talk. Most no, they don't.
I've seen judges in Wayne County, and you're right, because the defendant has to make a record for purposes of appeal, because raise it for the first time on appeal, they're going to say there's no record evidence. But what I've seen some judges behave so shamefully on the bench, because they understand what you're talking about, Ms. Payne. They understand that the defendant is trying to put certain things on the record about their attorney's performance, or any And I've seen judges cut them off and not let them finish. So it is intimidating. Here's this authority figure on the bench, basically, I don't want to hear it. You got one of the best attorneys in the county.
Yeah.
Shutting down.
Yeah.
And I guess it's not the end of the world, because part of the record was made, and so the Court of Appeals can see that this judge did not let this defendant make that record. But I've seen judges do that, and it makes me angry. I sit there and I'm thinking to myself, Your Honor is doing that because that defendant is trying to make a record for purposes of appeal, and they don't like it when you wise up. I'm speaking in general terms. These judges, I've seen judges behave like that on the bench, and I'm thinking to myself, he's not satisfied with his attorney's performance, and you know what he's doing because he's getting ready to go to the Court of Appeals, and you're shutting him up.
Mm-hmm.
That's wrong. So, but you are right. At least make an effort, especially after the Lafleur versus Cooper case by the U.S. Supreme Court, where it said that the defendant has to speak up on these plea bargains and make a record of it. I think on anything else, if you're not happy with your attorney's performance, hey, you better speak up.
That's
you
right.
may not, you may not be the best articulator, but do your best. If your attorney is sleeping at the table, or you smell alcohol or something on you, especially if your attorney is under any kind of influence, my God, speak up. The judge can't smell it, but you can. You're sitting right next to him. At least do your best. And I think for the most part, most courts will let you speak up if your attorney, is smelling of alcohol or drugs. But they're officers of the court, and the courts don't like that either. But Ms. Payne, I have seen that in Wayne County where judges shut these guys up, and women, when they know what they're doing. They know they're trying to make a record for purposes of appeal, and then you have the judge basically telling them, "Shut up, be quiet. I'm the judge." You have one of the best attorneys in the county. All this other stuff. It's just wrong. It really is.
Yeah, I've seen that.
What I would encourage that to prevent that, I've seen that. I did something similar to my attorney. He went and made some type of agreement with the prosecutor out of my knowledge. So what a friend of mine did, I had no problem with it. No, none whatsoever. I mean, because they used to put me on diesel therapy. And so I was laying in the bed. I'd never forget that night. And one of my cousins was in there with me. So I gave him my paperwork, and I went and laid down. And he read through everything. He said, "You gave him another time extension, this, that, another thing." He requested for that. I said, "I didn't sign up for that." He said, "It says so here." I got out of that bed. He said, "You're going to get up. You're going to write a letter." And this is what I would tell y'all to tell your clients. Get up and write a letter. I took that letter, and I wrote that letter. When I got up that morning, I put the letter in the mailbox. When I went before the judge, and I met with my attorney came to the holding pen, and I told him what I was doing. I said, "I'm reading this letter. I already sent it out, but I'm going to read this letter to the judge because you had no business doing what you did." "Oh, no," I said, "I don't want to hear it. I want to." So when we went before the judge, this was before my letter even got there. The attorney started, "Oh, I'm sorry. I should have notified him first, and this, that, and other thing." So the judge said, "Well, it doesn't matter if you notified him or not. I'm denying you and the government's motion. No more time extensions." So that was just fortunate for me. But what I will say is, I will encourage y'all to tell your clients, if y'all got you can fill your judge out for a few hearings you did, so you know what you're working with. Write a letter. That clerk of court will document that letter. You're establishing a record.
That's right.
Whether it's not about granting it or denying it. We hope it, whatever. But you're establishing a record. So this way, when you do go to appeal, they cannot say it wasn't on the record, or the judge didn't know and you didn't try to put it out there.
And they may have a chance for an evidentiary hearing.
Also, send a certified return receipt, because they'll play games with your mail. I encourage that.
The other thing that you can do is get a family member to do the same, to handle that and get it to the judge, and give a copy to the attorney, so that the attorney knows that we're not stupid, and we're gonna, if you don't advocate for us, we're gonna embarrass you, and we're gonna advocate for ourselves. Attorneys don't like that. They don't like to be embarrassed.
So literally, you're fighting for your life. So you have to use all the tools
That's right.
that you can before you get into the system. So if just in case you happen to get there, you will have these things in your pocket to help you, to your tools to fight on appeal.
Yeah. J-Love, let me say this here. One thing that I encounter all the time is people thinking that people accused of crime, that everybody's trying to get something for nothing. Okay, in other words, you really are guilty, and all that, because we wouldn't go through this time and effort and money if you weren't. The police have got better things to do. Prosecutors got better things to do than to try to railroad you. You ain't nobody. You probably don't even vote. So what I'm saying is that all the time I'm confronted with people allegedly abusing the system. Okay, now I'm gonna give you two examples, so y'all put this in your lexicons if you don't already know it. There was a U.S. Attorney General by the name of John Mitchell. He was Attorney General in the Nixon administration.
Mm-hmm.
Now, John Mitchell was one of them law and order types. Lock them up. Damn these bleeding heart liberals. Damn all this liberalism. These people got too many rights. But when his step and fetch it behind got charged, he became the greatest advocate in the world for civil rights and liberties. See, his ass, excuse me, I'm sorry. His behind was up there, all kind of things. The Constitution got to be upheld. People have died all over the world for this Constitution. Our blood is on the flag in foreign lands. I said, you punk.
Yeah.
You undeniable punk. And then, so in a more contemporary sense, a man by the name of Darren Chauvin, or Derek Chauvin, whatever, okay? The man is accused of putting his knee on Mr. Floyd's neck for over 9 minutes. Do you know, which is one reason I really am so glad you brought this up, he is claiming now ineffective assistance of counsel.
Mm-hmm.
Because now remember, this police officer didn't give a damn about the Constitution when he's on the force, all right? And trained other police officers not to give a damn about the Constitution when he was there. But now he's saying my constitutional rights have been violated. I did not get effective assistance of counsel because he did not tell me there was a pathologist or whatever who would have testified that Mr. Floyd did not die from my knee on his neck crushing his windpipe. He died from some other drug related, some other kind of a thing like that. So it really tickles me when I hear this man stand up and plead about the Constitution when this man was the main perpetrator of denying people constitutional rights. So the next time, y'all, somebody try to bring that stuff up to you, say, well, Mr. Chauvin don't think the Constitution is applied wrongfully. He's a great supporter of the Constitution, y'all. And anyway, I just had to share that.
Part of that privileged attitude, right?
Right.
Our laws, it benefits us.
That's right.
And it's interesting because I hear that our military fights for our rights and our freedoms. Who are you kidding me?
Yeah.
Because they're violated over here so badly.
Yeah.
Right. Yeah.
Saddam was not a threat to our Miranda rights and all these constitutional rights, nor our way of life, nor our freedoms. Who are you kidding with that? When I see, I take it to heart, and I guess that's why I like the work that I do. When people's rights are violated, because I hold dear to that, even if I believe they're guilty.
Yes.
I won't let the client know. I won't even let the client know that. Even if I feel they're guilty, even if someone wrongs me, I'd be the first to say that person is entitled to the full panoply of their rights in court, because we claim we have the best justice system in the world that's built on these rights. Then we should live up to it. But I see so many repeat violations of people's fundamental rights that it has scared me. It has stirred me to act. And not only in the legal profession, but being an activist. Some of the rallies I've been to, like I can't help but to hark back on the case of Devontae Sanford. That was the worst in my 28 years career I've ever seen in terms of prosecutorial misconduct, police misconduct. It was over the top. And they knew that boy was innocent, and for 8 years they fought and kept him in prison. Yeah. And then I hear that the military went to defend his rights. You're liars. You're defending my rights. You're a liar. Who are you kidding with that? The threat to our rights are the police and dirty prosecutors. And I'm not anti-police. Don't get me wrong, but I'm anti-corrupt police. I'm anti-police brutality. I'm anti-dirty prosecutor. And I just, what? I can't say it enough. If you're going to put me on trial, then give me my rights. Give everybody their rights. It shouldn't be a privileged right to nobody.
That's right.
Right.
That's right.
That's right.
Oh, and by the way, speaking about rights, the jury verdict has got to be unanimous, right? Now, the only police officer that ever got charged in the killing, of a woman by the name of Breonna Taylor, in Kentucky, hung jury, Now the government is saying we couldn't convict him the first time with all we had. We have to find a reason to think we might be more successful the second time. Now, and so what I'm saying is that there's that privilege aspect again, There's that privilege aspect again. And I'm going to say this, elections have consequences. And I'm going to tell you this right now. I'm so glad, and I'm repeating it again, so glad that the governor's race in Kentucky ended up the way it did, because I'm so glad Daniel Cameron is his name, the attorney general, the Trumpite, the Trump acolyte, happens to have a dark uniform, but he damn sure ain't on my team. And so you see,
that's right.
See, I'm so glad he didn't get elected governor. I'm so glad, because had that man been elected governor, that same benign neglect. Remember now, he wasn't doing nothing against some officers that killed Breonna Taylor and them. You got to remember that. that. So now nobody is being held to account for what happened with that woman. Now you say, well, yeah, they sued. That's only money, y'all.
Right.
Money is not always justice.
That is not justice. I know it.
No, but people, that's madness. People say they sued. So what? They sued for $20-30 million, and they act like it's not a big deal because the citizens of Michigan is paying for it. This is something we had a discussion about already, J Love. What they need to start doing is making them prosecutors and police get insurance. My thing, like I said before, you got doctors, you got lawyers, doctors and nurses. They are there to save people's lives. They're not supposed to want to kill their clients because our clients, they won't make no money. But them people have to get insurance to practice medicine. They have to get insurance to be LPNs and RNs. Here it is. This guy got the thunder of God on his hip.
That's true.
That is.
True.
And they don't have to get no insurance. And when they do something, it's never going to change until they have to. Because let me tell you, when they get that insurance and somebody do wrong, the insurance going to go up. It's not costing them nothing. Who's paying for it? J Love, you're paying for it. Hugo Mack, you're paying for it. I'm working in New York City. Eric Gardner, I'm paying for it. No one's paying for it. So why should I stop?
Yeah.
Right.
Yeah, it's
you got to get rid of qualified immunity. That's got to go.
Yes.
Immunity means impunity. That's what qualified immunity amounts to.
That's exactly
absolute impunity.
There's criminal laws on the book to charge officers, and even they have sent prosecutors to prison. They don't enforce it enough. Let me tell you something. A lot of these wrongful convictions that involve police misconduct, involves what? Witness tampering, obstruction of justice.
Mm-hmm.
Those are felony crimes. Suborning perjury? You mean to tell me a police officer who's coercing a witness to lie on you? That's not suborning perjury. So the officer, they keep their jobs. They're insulated. They don't pay those judgments because they get an indemnity. The city pays those judgments at a time.
Right.
But my point is, it's not just enough to charge.
You pay
them. Put them in prison. If you or I did what some of these officers do to witnesses in lockup, we would be charged with witness tampering.
That's right.
There's laws on the book to deal with it. But prosecutors and for the most, a lot of people in this profession, to them it's taboo. Oh, we can't talk about putting police in jail. Why not? Yeah. They put this innocent kid in prison for 8 years. They put some of our clients in prison. They shortchanged them justice. Didn't turn over exculpatory evidence. I don't have a problem with it. Why do you have a problem? No one wants to talk about that. Kim Worthy, matter of fact, she let the statute of limitations run on charging one of the dirty cops with perjury in Devontae Samples' case. And she says, well, I can't charge him because the statute of limitations run. You let it run.
That's right.
So there are laws on the book, but there's no enforcement to putting these cops in prison. You want some real deterrence to wrongful convictions? Start throwing the rascals in jail, in prison.
Yes. And I'm sorry, I must chime in. What what Abdul is saying is so right. I apologize, J-Love. Punish me by putting me in a quiet room for 20 minutes. I'm sorry. but what the man speaks the truth, because remember now, on a federal level, you had, to me, a black puppet, by the way, by the name of Tim Scott, a senator from South Carolina. He was the one that Uncle Mitch McConnell, his daddy, I'm sorry, I shouldn't have said that. I'm sorry.
No, you're right.
He's the one that Mitch McConnell put up. You know, the only black Republican senator is, okay, boy, you going out there, you be our face dealing with these other Brillo heads. You be our face, and then you go ahead on, and we're gonna put you up on this old qualified immunity thing, boy. Now look here, boy. Look here. Now we're gonna go this far, but no further. Yeah, y'all's a captain. I understand, Captain. I understand. And so what happened was we were stymied from getting any federal legislation done on qualified immunity because Tim Scott spearheaded the Republicans in the Senate, because remember now, you got to get to 60 votes, not just 50 in the Senate. You got to remember that. And torpedoed the whole thing on holding police accountable. So we've never had federal legislation that would make one uniform standard, okay? And as long as the table is the way it is now, until they do away with that filibuster stuff right there, it's going to stay that way. It's going to stay that way. Even if the Democrats take over the House in 2024, as long as that 60 vote necessity is there, it's not going to happen. So back to what Abdul was saying. So it's got to come back down to a state level.
That's right.
You know, it's got to come back down to a state level. And I'm going to say this. Everybody here knows that we lost 2 seats in this last election in the House of Representatives, in the state of Michigan. The Democrats no longer control the House of Representatives. It's a 54-54 tie. Okay, so that's going to make it even harder, because J. Love was kind enough to have a man by the name of Jimmy Wilson Jr. On the show some weeks back, and things he's trying to do. Well, now we were struggling when we had a majority in the House, in the Senate, and the governorship. I mean, it's just another, I don't know, bag of sand on our back now to try to get in anything done. So we just got to keep fighting on a state level, because I don't see a bunch of stuff happening on the federal level the way the system is set up. I hope I'm wrong.
But I have to chime in and tell you though that don't hold, Republicans are villains to most of us. But let me tell you something. Democrats get in office and do the same thing to us that Republicans do.
I agree.
Democratic prosecutors do us the exact same way that and you talk about people wearing our suits, you know, they're just as bad. You got one right there in Detroit. So you know, we you know, prosecutors get in there and do the dang thing on us, and we've got the same amount of people, the same percentage, whether going to prison and wrongfully convicted, whether it's a Democratic prosecutor or a Republican prosecutor.
Right.
They all sing out of the same hymnal. So don't be holding up, you know, I you know, and as far as I'm concerned, the same thing happens on the national level.
Mm-hmm.
Well,
because once they get in these seats, the culture it continues. You know, they say all these great things as they're running.
Yeah.
You know, they're promising this and promising that, and I'm going to. You know about Attorney Matt, and then when they get in there, they go right as business as usual.
Right, but
the people still are, you know, in harm's way, because you don't have anybody else going to step outside the line and say, "Hey, I'm going to change this. I'm actually going to change something." Right.
But I want to clarify something. The reason I said what I said is that at least with the Democrats, see, they passed the George Floyd legislation through the House when the Democrats was there. See, they passed all that. Okay, it was the Senate. It was the Senate that stopped it. If it had gotten through the Senate, Biden would have signed it. So I've said this before, and I want to say it again right now. By and large, Democrats give black folks a headache, but with the current leader of the Republican Party right now and what he promised to if he get back in, they will offer black people a lobotomy.
They already are offering us lobotomy. You're right. You're right. And there are those of us that are getting in line for the lobotomy.
Sister, truer words are never spoken. That's exactly right.
And Tim Scott is one of them.
Absolutely. And talking about we ought to be giving them accolades. Accolades for what? This man announced, J Love, please. I'm sorry, J Love. Hey, Kevin, bear with me for 30 seconds, brother. I'm doing 30 seconds and I'll be quiet, I promise. This man had the temerity to announce his candidate for Senate right there where the damn Civil War started. This black man, what is it? Fort Sumter, South Carolina, wasn't it Fort Sumter? Yeah. This man had the nerve to talk about the greatness of America. And I said, you coon, you stepping, fetch it, dancing, skinning and grinning, watermelon eating coon. You got the nerve to stand there where the Declaration against black people was put out front and permanent. And you're going to talk about the greatness of America and the greatness of what we are? Are you crazy? Yeah. So look, anyway.
Yeah. No.
First, they put their face out there to make you think that a change really came, right?
Yeah.
That's right.
He's just wearing the colors. That's right.
Wow. That's right. So you know what? So please don't look to me to cry because the man is out the race. See, I guess y'all figured out by now. I didn't send the man no donation.
You did?
I didn't know he was really. Look, it didn't seem like he was really in the race. To be honest, he was just there.
Yeah.
Talking about the story of his life.
Yeah. And then, okay. 30 seconds, y'all. I'm sorry. 30 seconds. 30 seconds. I'm sorry. And then what got me is got the nerve to talk about he was raised in poverty by a single mother. Who had value and encouraged him and his brother and supported him. And I wanted to reach through to the TV if I could and slap him. I said, excuse me, porch man, you mean to tell me you talking about all the disadvantage you had and your mama did everything right. So you talking about black people don't have moral fiber. Your mama had moral fiber and you still was poor ass. So what are you talking about? You know, what are you talking about? Y'all was on welfare and struggling. What you talking about? Putting somebody else down. So, anyway, I'm good.
How soon we forget?
How soon?
Yes.
Yeah.
Yes. So this was a great conversation.
I'm sorry. No, I'm sorry. I am. I'm sorry.
This is a great conversation. And also, Kevin, I'm with that insurance. Like I'm really with that because guess what? If you can't get insurance or your insurance, nobody want to insure you, then you don't have a job. If you keep on doing stuff to make your insurance prices go, and then the insurance company say, "Hey,
Mhm.
like in Detroit, they had a police officer that had 85
Lawsuits.
or more complaints, right? If he had insurance, I'm thinking like 85, he was uninsurable. He would be uninsurable, right? So
That's called hurricane insurance.
right. So he would be able to work. You know,
Like, what?
who's gonna insure him? He probably couldn't even afford the premium, right? That means the taxpayers will have to be paying this lawsuit because the insurance company don't even want to pay them.
That's right.
So these are the things when you say elections have consequences. We need to educate. This is exactly why we come here to have these conversations, like to trigger thoughts, to get people to think, to look at stuff, like to turn off the mainstream conversation and really let's just get real about what's going on, because what's going on is your people, your loved ones, yourself are getting railroaded into a system that don't care about you. So you have to care about you enough to get involved to make change happen. So I'm glad that you guys joined me tonight for this conversation. Rabatia, do you have something that you want to leave us with?
Oh my goodness. I just want to say thank you to everybody tonight. This was a rich conversation and just want to empower people this evening that you are able to be that checks and balance. You got to start off checks and balance for yourself. When you're seeking justice in any way, shape, or form, you got to know that you have a balancer within you. You got checks and balances that you can look for yourself. You got to do your investigation. You got to go after it. And you got to go after it with all your might, knowing that you do have victory, that yes, God causes you to triumph, but you got to believe it. You got to believe it before you got to expect it. You got to believe it and you got to expect it. And then check who you're working with. Whatever lawyer you choose, do the background check him out. Check him out and see if he can pass the test. Now, if your attorney does like mine, whenever he talks to the judge, he's calling. He don't send you an email and he don't call you. And if he asks you for documents, look, I had text him, did you pick up the documents? And guess what? He didn't respond to that. He called me. By the time I called him to see if he got them, he answered and said, well, I didn't see your text, but I do have your documents. Now, that tells me something. I didn't have to wonder about, and this is what's key. You should not have to wonder about what is happening between the judge, the prosecutor, and your attorney.
That's true.
And if you get in a play-by-play,
That's true.
it's just like with basketball or any other. Look, you better know the play. You got to know the game plan. If you know the game plan and you're able to see it and know it and not have questions about it, and that lawyer is answering all your questions, then yeah, he's the one or she's the one.
Right.
Okay.
Thank you, Rabatia.
Thank you. Thank you, Attorney
Kevin.
Mack, Attorney Payne.
Kevin, what you want to leave us with tonight?
Well, this is first I'd like to say thank you for having me on here, and Attorney Ms. Payne, thank you for the work you're doing regarding making sure that indigent people who have these mentally ill, that are mentally ill, get fair assessments of their illness. So when they go before the court to see if they are competent or not, they get a proper assessment, not some just ram through the system and nothing's really done properly. I also would like to leave the viewers with this. I don't care if a man is, you deem a person right, or if you deem them wrong for whatever they've done wrong, right? And you want to hope the worst for them or the best for them, either way. Let me explain one thing to you. When it comes to railroading people and disregarding the law, it starts with those who may have even broken the law. And once they get you all set and comfortable with ramming and railroading them, then it'll be your little brother or your little sister who didn't break the law.
Mhm.
So the main thing is this, what I'm trying to say, make sure everybody is treated fairly under the Constitution of America, under the law.
Mhm.
That's all anyone can ever ask for, is a fair trial and to be treated fairly. So, and another thing, jury duty.
Amen.
You have to start going to jury duty. It's too many times I see too many of, especially the black people. I've watched it in every try to duck that jury duty. You want to come out, you want to burn down buildings, you want to tear up the streets, you want to blame the white man, you want to blame. No. Start doing your civil obligations and going to jury duty, because these other people are. And then you want to get mad and expect a different outcome. This is why they call it jury of your peers. Come out and go to your jury duty. Do your jury. So what? Miss a few days of work, because you're gonna miss a few days of work out there throwing bottles and busting. Look, just go to jury duty and start making a change. You know, in your community, as in society as a whole. Otherwise, and J Love, thank you for having me, and y'all have a good night. It's been an honor meeting you, Abdul Hakim and Attorney Payne. Y'all be good.
Amen. Amen.
Kevin, I'm glad you brought that up, because that was jury duty was one of the reasons why this platform was created. You know, when I was sitting with Gerard, you know, going through that with him, I saw a lot of people that looked like me had 1,500 reasons why they didn't want to sit on that jury.
Mhm.
But nobody that didn't look like me had a reason. They wanted to stay. And so when I got out here advocating, one of the goals was to advocate to people who don't look like me, because you don't get to really hear my story from me. It's always narrated through somebody else.
Mhm.
And so, but also, we also have to, I absolutely agree with you about us going to jury duty, because it could be you. And you could be sitting at that table looking at everybody making an excuse to leave out of there. And your peers is a whole bunch of people who don't look like you. So we have to do it. And I know people feel like, hey, I don't want to do that. I don't want to go. Please, 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 please. It's important that we go, because also that's the way we find out what's going on.
That's right.
You don't know what's going on until you get in that courtroom. While I was in there, I saw other cases, and I found out about different things that was going on in the community that I didn't even know about, because you know, I'm living my life. But now I'm there, I'm hearing stuff, I'm educated not only on what's going on with my son, but seeing what's going on with other people. So it's important. Thank you, Kevin. Mr. Abdul.
I like that the points that are being made about the importance of jury duty. And here's another reason why. Because of all of the wrongful convictions, right?
That's right.
You want to be one of those jurors that will hang the jury if you listen to the evidence and you firmly believe that that person is innocent. So give that service. It is important. And I like what Tia said about empowering yourselves, and what Kevin said about the civic duty. Well, one of the ways to empower yourselves is to educate yourselves. Know your basic rights. You watch all these crime TVs, a lot of it's true. The example that Miss Payne gave earlier about when the police come to your house, oh my God, I can think of a million examples of what can happen when they come to your house without a warrant, and what you decide to do to make it easy for them. They don't have to Mirandize you when they walk in your house and they start questioning you. You're not in custody. They don't have to get a search warrant for the examples we gave. Just, you know what? There's in this information age, there's no excuse. What we talked about today, if you leave here without knowledge of what we talked about, there's no excuse for that.
That's right.
What we've been talking about in all of these sessions, and just, I mean, Google is there. Go to some reputable constitutional law classes. Educate yourself so that you don't have to be faced up against being prosecuted before you decide, oh, I got to learn what's going on. It's too late.
Mm-hmm.
Educate yourselves. And lastly, let me say this. Don't let them think that they can fool us to believe money is justice. Money alone is justice. Yeah, compensate me because damn it, you owe me for it. But true justice, true deterrence comes to putting these corrupt police and prosecutors in prisons. And until I see that done, I'm not going to get tired of saying it. Yeah. We're going to be spinning our wheels. So talking about solutions, their solution is there. But don't let them insult you. Like Barbara Bush did during Hurricane Katrina and said, oh, they'll be happy to get that little FEMA money. This wrongful conviction money is just as insulting for them to think that they can compensate you and keep these bad officers out here continuously violating your rights, beating the crap out of us, and killing us. Don't let them insult you by letting us think that money alone is justice. No, it's not. It's good. I'm going to turn it down either, but I know better because I know what justice means, and you got to know what it means. Accountability, not just money. Accountability. We still don't. We need it. We haven't gotten it yet.
Yes. Thank you, Mr. Hakeem.
Thank you,
Attorney Payne.
Well, I for an old lady. I'm that usually in bed by 8:30. This conversation couldn't possibly have put me to sleep. I mean, I'm invigorated. Now I'm ready to go out and fight. Abdul, it was such a pleasure meeting you tonight and being on this panel with you. You're absolutely right. And I learned some things. And Kevin, you are just an inspiration. You know, I love that. I love your story. I love that you're doing what you're doing. We need brothers like you that are in prison who have improved their lives, who changed their lives, to come out here and do what you're doing. We need you. And so you're the inspiration. You're the hope that we look at and say, this is what we can do. This is who we can be. I'm so proud. I'm so proud to know you.
Thank you.
And I'm so excited by what you're doing. I'm geeky. And Tia, my daughter, she's Tia. She's my inspiration too, because I have to lean on her sometimes when times get tough. And J Love, of course, you're all of our inspiration because we look to you and for your strength and admire you for who you are and what you've done, turning a moment into a movement. My girl. And brother Hugo Matt, my brother-in-law. I love you, man. I love you. Kevin, you're right. We started off talking about ineffective assistance of counsel, and then we started talking about ineffective assistance of citizens. And you are absolutely right. I've gone to trial after trial after trial with juries with no Black folks on them, trying Black folks. And in fact, the conversation in our county during plea deals and plea conversations, a lot of time is, are there going to be any Black folk on my jury? Then I'll take the plea. What a tragedy. What a tragedy that people don't trust the system to the point where they'd rather plead to something they should not plead to. They didn't do it, but they'll take a lesser plea in order not to get a sure conviction
That's right.
of something that they didn't do. It's a terrible comment on our system and the systemic problems that we have in our criminal legal system because there is no justice. And for all of us, I love it because we've decided that where there is no justice, there will not be any peace.
That's right.
Yes.
We're going to keep speaking out, keep fighting, and doing all the things that we need to do to make sure that there's no peace. It's been a pleasure. Thank you for allowing me to be here and be a part of it.
Thank you, Attorney Payne. And Attorney Mack.
Well, look, the hour is long and my words will be short, okay? First of all, a man named Al Sharpton ran for president, and the polls say that he didn't win. I disagree. I ran for Washtenaw County prosecutor in 2020. The polls say I didn't win. I disagree. Because it's not about me winning, it's about my cause winning. It's about my cause winning, okay? And I'm proud to say that we have recommended legislation through my state representative, Jimmy Wilson, to allow returning citizens the right to sit on a jury. The right to sit on a jury. Let me explain about my story, which I think is so compelling. And I've said I'll testify in front of the Michigan legislature. I look forward to doing it. I'm an attorney with a criminal justice experience, the Michigan Department of Corrections. So the state of Michigan, through the Michigan Supreme Court, has said, Mr. Mack, you are worthy of the trust and respect of all 10 million people in the state of Michigan. 10 million people in the state of Michigan. The highest court in this state has said that. But the Michigan legislature has said, Mr. Mack, because you have a criminal experience, a penitentiary experience, you are not worthy to sit amongst 12 people. You are not worthy to sit amongst 12 people. So I may be the only lawyer in the state of Michigan, only person in the state of Michigan. I'm qualified to pick a jury, but I'm not qualified to sit on one. Now think about that. Think about that. So I contacted my state representative and said, this is wrong. You talk about if a man or woman is paid a debt to society, then why don't you let that man or woman sit on a jury? Why is that? Why are they tainted for the rest of their lives with a scarlet letter of untrustworthy or liar? Okay. If anything, a person that's been through a criminal justice system knows what it's like to be in a system, and they're going to be damn sure not to let somebody go in that system unless they deserve to go in that system and been proven. See, so if anybody, you need a whole damn jury full of people who've been in the penitentiary. See, that's the best way you get your verdict right now, because so anyway, so I'm proud to have tried to start that legislation in the state of Michigan. And so please just keep fighting the fight where you at. You know, the light is brightest at its source. Okay. So wherever God have you planted right there, you flourish in that garden because you doing something and it's going to make a difference. It's making one right now. And I love you.
Yes. Thank you, Attorney Mack.
That is very
so
important.
yes. Thank you, everyone. Join us. We'll be back next week. Again, I talk about Crystal. She is one of the people that I've been advocating for, who is in the Michigan Department of Corrections right now, sick from a mold exposure, black mold exposure. This is what Crystal, the before picture before she became sick, and then this is her now. And I received like letters because the group is working for trying to help her get clemency. They're really taking her through a hard time there at Huron Valley. So this is her information. Crystal Denise Clark. Her number is 435064. Women's Huron Valley Correctional Facility, 3201 Bemis Road, Ypsilanti, Michigan, 48197. If you guys can just reach out to Crystal and send her a letter of support. We have we're writing a governor on her behalf right now to look at what's going on in she knows what's going in there. She knows about that black mold. But just we're standing up for Crystal. Tomorrow, it's the third Saturday of the month, so we have the wrongful conviction task force meeting and support meeting. You can find that information on Facebook under Trisha's Facebook page or Survivor Speak. And we'll be back next week. I'm sure Kevin's going to be back with us. So until then, you guys, thank you for joining us on Turning a Moment into a Movement, and we'll be back. Oh, as a matter of fact, Mr. Hakeem, we're going to be back with Miss Diane.
Oh, my co-rebel.
Right. So you guys, see you next week, Turning a Moment into a Movement.
Stay up.